The attractive nuisance doctrine. When someone is on a private property and becomes injured, it's the fault of the trespasser, and the landowner would have no responsibility in the injury. However, when a judge has a case before him and he knows the right judgment will be unfavorably looked upon by the public, he will find a way to make a decision that's more favorable to the public. The term attractive nuisance was first used in a case in the 1840s that involved a railroad turntable. One such judge and many after have done this by way of using the attractive nuisance doctrine. Here's how they did it. It's commonly accepted that anyone who has property that is not held in common, that the property is not to be trespassed upon. This is common sense and is long-standing. When someone trespasses upon someone else's property, they are the lawbreaker. So when a little girl trespassed upon corporate property and became injured, the judge understood that ruling in favor of the corporation would have been an unfavorable decision. So he used a fiction by creating a doctrine called attractive nuisance doctrine. The judge in this case decided that the child was, quote, deemed to have invited. So the corporation was deemed to have invited the child by the things on the land, and therefore the owner of the land enticed the child to come onto the land where she was then injured. This allowed the judge to make up a fiction that would then allow him to make a decision that would be favorable to public opinion. The attractive nuisance doctrine was therefore used to charge the corporation who owned the property with negligence and to take the blame for the injury or death that occurs to people on their property, even though when those people are illegally trespassing. So this is one way in which attractive nuisance doctrine is used, but this is just an example of the many ways in which fictions are used in court opinions.